that's exactly what your position was in your filing, was that Beth was contacted and responded with regard to being cooperative.
Judge, I have a fact witness here, Dr. Kopetsky, who runs the supervisor release program. He's aware of the investigation. It was under investigation for a Chapter 980 placement. Actually, it was being looked at for a Kenosha County resident at that point, Thomas Johnson, who was granted supervised release in Kenosha County. Mr. Johnson has to have nursing home care, and he was inappropriate for placement there. So this is, to say it was done for Mr. McGee specifically, it wasn't done for him specifically, that would be correct. To say it wasn't done for a Chapter 980 placement would not be correct. There would be no other reason for the Department of Health Services asking people to do reports for a specific residence for a placement. That's the only placement.
Correct. It was with the 980, but in this case, one of the issues is there's a 1-year-old child living next to this residence. That's a relevant consideration with regards to the placement of Mr. McGee.
Judge?
Your Honor.
No. So you on the intervention, first issue, we're still, I'm trying to figure out who can sit in the room at the table. I'm satisfied county can. Parties clearly should be here. You're opposing the intervention of town and county. The department's here, notice of appearance, they're not intervening. My conclusion is the county meets the 4 criteria with regards to being able to intervene at this time, meaning they can continue the hearing. Mr. Terry. Mr. Peterson has a valid point as to intervention requires that person to meet certain criteria set out in the statute. Where does the township fit into those criteria? Understanding they have an ordinance. Beyond that.
To me, that's where the interest comes from. This order is seeking to contravene or abrogate our ordinance, and that may be very well possible under the change of law from Act 156. I would tell the court they can't overcome and defeat that ordinance if they themselves have not followed 980. Interestingly enough, another proposed placement in this law.
Where did they fail to follow 980 vis-a-vis the township?
Well, I think if they fail to follow 980, they shouldn't be entitled to the protections or actions of 980 to place in violation of our ordinance.
What specifically didn't they do with regards to the township as required under the placement statute?
I don't think they have any notification requirement to us. If they choose the sheriff as their notification point, that's fine. I mean, they do notify local law enforcement as well.
So your position is they failed to notify the township?
They did fail to notify the township until last Friday that this placement was going forward.
They failed to notify the township, and therefore you entitled to notice and you can intervene.
I think we're entitled to know what was done. If they're going to contravene our ordinance under Act 156, if we look at 980.
Terry, get over it. Okay, on intervention as to what specifically. Now, the county truly was notified, and the position is the department did, well, the notification occurred. They are alleging information appropriate to 980 wasn't sought or requested or investigated, however you want to say. How is the township's position on that same level able to permit you to intervene at this time? You weren't notified.
Correct.
You have an ordinance.
I would go back to Act 156, which is now codified under 980.08 sub 4. And if you're going to order placement out of Racine County, preference here clearly is Racine County, you have to find that there's good cause not to place in Racine County. One of the bases, or good cause, cannot be based on the presence of ordinance within Racine County preventing placement. We've seen nothing here that would allow you to avoid Racine County. And granted, we haven't seen much because much of this is protected. We're brand new in this case, but we haven't seen anything that says good cause exists not to place in Racine County, therefore we're going to place in Kenosha County, town of Wheatland. There's local harm here. I cannot point you to anything within 980. If we look specifically for the procedures laid out under 980.08 sub 4, usually D, E, E, M, F, we talk about county victim witness. We talk about law enforcement, which under this principle, we agree that that's been the sheriff's department at some point here, that there's a report prepared about prospective options. The statute itself says the county agency shall be contacted and do this. Local law enforcement shall be contacted and do this. I can't point you to anywhere within 980 that says you have to contact the town of Wheatland, or the town in this instance, and essentially vet it through them. I would tell you, it's my impression under 80309, we certainly have not had our interests heard in this instance. I started to bring up the Milwaukee County placement, and I would tell you in the Milwaukee County placement, everyone now agrees, DHS included, that that was under the definition, a serious child sex offender. Well, that gentleman was going to be placed up until basically the top blew off of this with the town of Wheatland and Kenosha County. To assert that, well, 980 provides this protection and the town can't intervene, there's direct harm to the town here. If it didn't already do what it did together with Kenosha County, there's direct harm to the town here if its ordinance is abrogated. And maybe it can be, but there's got to be some showing that the entity seeking to preempt it or abrogate it followed the rules. And we haven't, I think based on that position alone under 80309, our interests have not been adequately represented by the existing parties. No fault of the district attorney's office when we see a letter just of yesterday saying, nobody ever told us about the presence of a 1-year-old child. DHS would have placed the Milwaukee County offender directly adjacent to a 1-year-old child in direct violation of the statute. But for a meeting that was held a week and a half ago on a Friday afternoon.
Judge, I don't disagree with those facts, but they have nothing to do with this case. That's Milwaukee's problem.
Well, it's the town of Wheatland's problem too.
Well, then go talk to
I
Milwaukee.
don't want any argument. You understand that?
Yes, sir.
Terry, you're representing me that 156 requires the department to get hold of the township.
I am not, no.
What are you representing?
I'm representing to you that there has to be good cause by this court, and maybe it's there, I just haven't seen it. There has to be good cause by this court to basically place out of county. And good cause can't be the presence of ordinances within Racine County. Now, if that is the case,
Stop. On that specific point, Mr. Peterson.
And the good cause point?
Yes.
Judge, the court, you have the file in front of you. We started with when the state entered into the stipulation, we started a search.
So you're saying all the reports I've received during this case provided me with good cause because of the difficulty of placement that I know of?
Sure. I mean, Judge, you signed the order on June 22nd, 2015 for Racine and Kenosha because we couldn't find a placement in Kenosha. We had a motion to modify the supervised release plan because we couldn't find the placement, and you went statewide at that point.
Your Honor, may I
We have then a January 22nd order, which grants this and gives us a statewide search for Mr. McGee. We had the good cause hearings. We had motions, we followed the statute, it's specifically pled.
Tell me why he's skimming over the top.
Yeah, thank you, Your Honor. And I would ask DHS to weigh in on this as well, because I've had some conversations with them about this too. We don't dispute the procedural history of what happened leading up to this, and we know that it's difficult to find a placement, and we know that a lot of time and effort goes into it. However, March 1st of this year, the law changed. March 1st, and that's why I think Attorney Terry keeps referring to Act 156 and trying to say what it says. They specifically put a provision in there at that point that says, you know, you need to find good cause to look outside of your home county. Good cause can't be based on local ordinances and resolutions. So as far as from our perspective, the final approval of the plan to place him in Kenosha County happened in May 1st, which was after that March change. So sometime before that happened, this court should have been made aware of the fact that, you know, there may no longer be good cause to look outside of Kenosha County. Go back and take a look at it, because now the law has changed, and it went into effect March 1st.
Judge, and Dr. Kopetsky's here. He'll tell the court under oath they continued and continue to look for placements in Racine County, and there are none. So it's both pre and post Act 156 under both the pre and post Act 156 requirements. The department continues to comply. And I actually brought in someone who will testify to that.
You've been invited into the discussion.
Thank you, Your Honor. In terms of what the law in Act 156 says, I agree that a good cause finding is necessary. I do not have factual basis. I was not at the good cause hearings. I know that those existed, and we've made good cause orders in this case. Whether those good causes were previously based on local ordinances or not, I do not know that factual basis. And to the extent that good cause still exists, the placement is not in violation of the statutory provisions.
We disagree with that, but can talk about that when you're ready.
Judge, I think the witness might clear up some of these factual questions.
No, Mr. Peterson, this is my court, and I'll do it the way I want to do it, all right? Don't start throwing witnesses at me when I'm still trying to determine who can intervene. Fair enough? Intervention is surely based, in my view, on what we're dealing with procedurally.
I'm sorry, I misunderstood. I thought we had allowed.
All right. I'm just telling you that that's how I'm going to run it.